Reproduction, copyright infringement, and hot water systems. What do copyright and hot water systems have in common? Over the next few minutes, I'll explain this connection and what it means for Australian copyright law. Let's start with the basics. Copyright is a legal right that grants the creator of an original work exclusive rights over its use and distribution. Copyright is infringed if another party reproduces an original work without permission of the copyright owner. So what does reproduction mean in this context? Under Australian copyright law, reproduction means the following elements are present between work A and work B. The first is objective similarity, meaning there must be a sufficient degree of objective similarity or resemblance between work A and work B. Secondly, there must be a causal connection, or what Justice Wilson in this case simply referred to as copying, meaning work B must be directly or indirectly derived from work A. This formula was followed by the High Court in the 1985 case of SW Hart & Co Proprietary Limited and Edwards Hot Water Systems. This case explored whether Edwards had reproduced two of SW Hart's two-dimensional technical drawings of hot water system absorber units into three-dimensional products for sale. This case was an appeal from the full court of the Federal Court, which had allowed an appeal from a judgment given by the Supreme Court of Western Australia. This is how the High Court made out similarity and causal connection. Let's start with causal connection, or copying. Answering the question of whether copying had occurred centred on whether Edwards had access to SW Hart's drawings. The evidence showed that a former employee of SW Hart had in his possession the technical drawings in question and had not returned them after his employment was terminated. There was further evidence that the former employee had business dealings with Edwards, creating the causal connection. Chief Justice Gibbs, with whom Justices Mason and Brennan agreed, and Justice Wilson, deemed the trial judge was correct in establishing a causal connection. Next is similarity. The trial judge acknowledged differences between the two works, but stated that the similarities greatly exceeded the dissimilarities. The trial judge identified 16 points of similarity. Edwards argued that these similarities could be explained by the fact that they and SW Hart had relied upon commonly available sources of information to produce their works, such as other similar products and publications by the CSIRO. Edwards proceeded to submit 21 dissimilarities between the works. These included minor differences in dimensions and comparisons between both companies' final products rather than between SW Hart's drawings and Edwards' three-dimensional absorber units. Chief Justice Gibbs found these dissimilarities were minor, irrelevant to the question of reproduction, and could actually serve the purpose of deliberately disguising an infringement. Again, Chief Justice Gibbs, with whom Justices Mason and Brennan agreed, and Justice Wilson, deemed the trial judge was correct in establishing similarity. The additional question of whether there was either a whole or substantial part taken from SW Hart's drawings was also considered by Chief Justice Gibbs and Justice Wilson, and ultimately assisted in the decision that Edwards had indeed infringed SW Hart's copyright. So there you have it. That's how copyright and hot water systems relate in the Australian legal system. Thanks for listening.